Good evening, everyone, and welcome to the Ford Hall Forum at Suffolk University. I'm Jennifer Bernardi, the Executive Director of the Ford Hall Forum, where our programs provoke thought and encourage you to listen, learn, and engage. Tonight's discussion is about genetic technology, and it raises a lot of questions. If you had the gene for an incurable disease, would you want to know? Are you morally or legally obligated to disclose that information to certain people? Would it affect whether you have children? And what about putting a patent on a gene? Can you even do that? Well, apparently we can do that because we've been doing it for 30 years. But as of 3 weeks ago, the Supreme Court thinks otherwise. Is patenting genes exploitative, or is it an incentive for more research? So get ready to hear the answers to those questions and then ask your own. Before we begin, the Ford Hall Forum would like to thank our generous sponsors, including, among others, the Lowell Institute, the Massachusetts Cultural Council, the Barr Foundation, the Nellie Mae Education Foundation, and our partners here at Suffolk University, which serves as the forum's home base. We also encourage you to visit our new restaurant sponsor, the Woodward at the Ames Hotel, after the forum. Trust me, you will be starving by 8 o'clock, and there's a little map in your program, so you can get there easily. And finally, the forum thanks our members whose generosity makes our free public events possible. If you're not a member yet, I really encourage you to visit our information booth right outside here and become one on your way out. So allow me to introduce our moderator for the evening, President of the Ford Hall Forum, Dominic Ianno. Dominic Ianno is the current Director of Public Affairs, U.S. Northeast, in Pfizer's Global Sites Public Affairs Group. Ianno began his Pfizer career in January of 2008, joining the company in a newly created position as Director of Public Affairs and Worldwide Public Affairs and Policy, where he managed media outreach strategy for the company's interests on state policy and legislative issues throughout the Northeast. Prior to joining Pfizer, Ianno served 4 years as Vice President at Gray Media in Boston, providing political and business counsel to a wide range of business, education, and political clients. He is a past executive director of the Massachusetts Republican Party and worked as a research and media operative for several statewide Republican campaigns in Massachusetts. Ianno was named one of Politics and Campaign's top 100 Massachusetts influencers in June of 2010. Please give a hand for our moderator, Dominic.
Thank you, Jennifer. And thank you all for attending. I know this is a very fascinating topic. I will give a brief disclosure that is on my own, not even corporate related, but or corporate pushed. But I am moderating tonight on my own personal behalf as a private person and president of the Ford Hall Forum, and a topic that I'm very interested in. I don't want anything I say tonight to be construed as a corporate policy or anything like that. This is purely here to ask questions and bring out a conversation about this topic. So please keep that in mind, and thank you for understanding that. So I'm going to introduce our two panelists tonight. I'll ask some questions, get the conversation started, but per our forum, the best part of this forum is that you, the audience, get a chance to come up and speak, and we really like to hear what you have to say, your opinions, talk to our panelists here and who are both experts in this area and really have a lively conversation over this topic. So with that, let me introduce our two panelists. First, to my far right is Lee Bromberg. Lee is a trial attorney at McCarter and English who concentrates in the area of intellectual property and information technology. He has successfully handled a wide range of patent infringement actions as well as trademark, copyright, trade secret, and unfair competition cases in high technology areas. Lee Bromberg was named a world's leading patent litigator by IAM Patent Litigation 250 and has been recognized as a Chambers USA Leaders in Their Field lawyer from 2007 through 2012. He has been named among the top 100 lawyers in Massachusetts, listed in the best lawyers in America for intellectual property, and named as a super lawyer in the field of intellectual property. He has received one of the highest peer review ratings from Martindale-Hubbell based on a survey of other lawyers and judges. Bromberg's patent infringement practice on behalf of numerous national companies has involved a wide array of technologies, including pharmaceuticals, biotechnology, and recombinant DNA. He has served as a court-appointed discovery master in patent litigation. He has testified as an expert witness on patent litigation and led the task force that obtained implementation of local patent rules in the Massachusetts federal court. Bromberg has previously served as Clinical Associate Professor of Law at Boston University School of Law and is the president of the Boston Patent Law Association. He's currently a fellow on the Boston Bar Foundation and a board member of the Ford Hall Forum. Lee Bromberg. And closest to me, Dr. Robert Klitzman is the director of the Masters of Bioethics program, the director of the Ethics Policy and Human Rights Core of the HIV Center, a member of the Division of Psychiatric Law and Ethics, and co-founded for 5 years, co-directed the Center for Bioethics at the Columbia University College of Physicians and Surgeons and the Mailman School of Public Health. Klitzman has written 7 books and numerous articles drawing on multidisciplinary methods to examine ethical, psychological, and social issues in a variety of contexts in medicine and psychiatry. Specifically, he has examined decision-making concerning HIV disclosure, genetic testing, reproductive choices among individuals at risk for genetic disorders, institutional review boards, and other topics. And he is the author of Am I My Genes, which is, I believe, available tonight, and he will sign after the event. And we have somebody already lined up for you. Dr. Klitzman. So to get the conversation started, Lee, I'll turn to you first. Jennifer mentioned the recent Supreme Court decision. If you could, as this has gone through the courts and now we have a Supreme Court decision, can you just lay out the general legal issues and perhaps give a sense to the audience who's on what side of the issue?
Okay. Well, the Supreme Court came down with a decision just, I think it's 3 weeks ago, in a case called Mayo versus Prometheus. Most people call it the Mayo decision. I like to call it Prometheus because it's got a, kind of a mythic quality to it. And in that case, written by Judge Stephen Breyer, Justice Stephen Breyer, who, as you know, is the Cambridge representative on the Supreme Court, the court ruled 9-0 that Prometheus's claims, which were method claims, were not valid because they just covered essentially laws of nature. And this decision has sent some shockwaves through the patent community because it was so sweeping and actually unexpected. I was at the annual judges' dinner for the New York Intellectual Property Law Association, which is known colloquially as the Patent Prom, because people get dressed up in tuxedos. And the honoree was Alan Lurie, who's a judge on the Court of Appeals for the Federal Circuit. And the Federal Circuit hears all patent appeals from around the country, and the only step beyond them is the Supreme Court. So Judge Lurie, as the honoree, started his remarks by saying, it's really nice to receive this award 3 days after I've been reversed by a unanimous Supreme Court. So what was that case about? Well, it was about methods for measuring metabolites of thiopurine drugs and then looking at the results and determining whether the metabolites indicated the dosage was ineffective or the dosage was too much, and making adjustments in either case in the appropriate direction. Those were the methods that were patented. And the Supreme Court said, well, wait, this is just relying upon laws of nature, the way the thiopurine drugs work in the body, and the results are all well known to everybody about if the metabolites are at this level, you should move the dosage down, and if they're at this level, you should move the dosage up. So no one gets a patent for that. Well, that was a bit surprising because the law of nature exception to patentability has been thought of as much more grand in scale, such as you can't patent E equals MC squared, or you can't patent some other phenomenon of nature, like if you find a new element in the earth. The element is there and you find it. You can't patent that because it's something that nature itself created. So this has created concern in the pharmaceutical and biotechnology industries, which are a very important part of the Massachusetts economy, as you all probably know these days, because there are thousands and thousands of patents on new compositions, on methods of using them, on dosage methods, et cetera, and people are wondering about the viability of those patents. In addition, the Supreme Court in the Prometheus case, the Mayo case, said that they were going to remand for further consideration another case which is called the Myriad case. And the Myriad case involves the patentability of isolated gene sequences. And in that case, the isolated gene sequences that were patented are the so-called BRCA1 and BRCA2 genes. Those are gene mutations, and BRCA stands for breast cancer. Breast cancer 1 and breast cancer 2, you can be tested genetically for the presence of these genes in your makeup, and if you have them, they show that your likelihood of developing breast cancer in your life goes from a very low level to quite a significant level. So this is an important kind of consideration for people to know this information. I know Robert's written extensively on this very subject. Do you want to know, and so on and so forth. But those patents were challenged in the Southern District of New York. The judge there said, this is natural stuff, you can't patent it. The Federal Circuit that I've referred to a moment ago, that hears all patent appeals, said, oh no, we do this, and these are appropriate. And as Jen said in the intro, isolated gene sequences have been patented for 30 years now. It's a well-accepted practice, and indeed some companies have built their whole existence and success on these kinds of gene patents. So in the Mayo case, the Supreme Court said, take that one back and take another look at it. Now, patents on isolated gene sequences are patents on a composition, a chemical composition. So that's different from a patent on a method. And the Myriad case has both kinds of claims. So nobody really knows what the Supreme Court's remand means. They don't tell you. They just say, take another look at this based on what we did in Mayo versus Prometheus and see if you come out the same way. And that's something that will probably take at least 6 months and possibly a year before we get a new ruling from the Federal Circuit about whether they're going to change their mind about what they did in the Myriad decision based upon the Mayo decision. So this has become very controversial in the legal patent community and in certain industries where these things are very important. And maybe I should stop there and
Okay.
and go on.
Sure. I do want to ask Dr. Klitzman a little bit about his book and to talk a little bit about some of the experiences, or maybe pick one specifically, because this is very interesting. You know, what do we know? What do we want to know? What are we obligated to know or share? So can you just share a little bit about some of the stories?
Sure. And I just want to say, by the way, thank you to the organizers for putting this panel on, because I think these are very important issues, and as I'll explain in a moment, and thank you all for coming to listen to this. I thought I actually would just give a little bit of background first, because I think not everyone may be on the same page in terms of genetics. And as background, next year is the 60th anniversary of the discovery of DNA. And it turns out that we each have 3 billion molecules that are lined up as strands of DNA in our body, and it's 4 molecules that we abbreviate ACTG for actinine, thymine, cytosine, guanine, and these 4 letters lined up 3 billion times are the instructions for making each of us. So I may have my 3 billion letters may be AATCG, his may be ACTGG, his may be CTTGC, etc. But it's those 3 billion letters that make us. The issue is that the cost of sequencing, of seeing what those 3 billion letters are that make me, me, and you, and me have my hair color and eye color, and you have your hair color and eye color, the cost of sequencing that, it was first sequenced 10 years ago, and the cost was $3 billion. $3 billion for one person. The cost is now just a few $100s. It's less than $1,000. And so when you walk in the door of the Mayo Clinic today, or Vanderbilt University, and every other medical center wants to do this, they are now taking part of, at least these Mayo Clinic, for instance, is taking a sample of your blood to sequence all 3 billion letters that make you. So when you go to the doctor in a few years, they'll be able to say, well, I see here in front of me your whole 3 billion letters, and I see that you have the mutation for breast cancer or Huntington's disease, and I see that for a certain medication, you'll do well on, for a certain condition, you'll do well on this medication, whereas you'll do better on a different medication. I see whether you have a 20% chance of getting Alzheimer's disease, whether you are a carrier for autism, for instance, coming down the pike. Whole sorts of diseases we'll be able to find. Now, at the moment, I interviewed people with breast cancer, and if you have the breast cancer gene, and BRCA, which is for breast cancer, BRCA, if I have, about 10% of all breast cancer is the genetic kind, and if I have the mutation, that means I have about a 50% chance of getting breast cancer. Now, it's a little ambiguous because I could have the mutation and not get it, and I could not have the mutation and get it, right? So it's a little bit confusing. The problem, and what's at core here, I think, are issues in part of costs and issues of law versus morality. So right now, if I have breast cancer in my family, if my sister wants to find out if she has a breast cancer mutation, the actual test costs about $50, but she is charged $5,000. And the reason she's charged $5,000 is because Myriad patented, quote, patented the gene, right? Now, that means that anyone in this room who wants to test so they have the breast cancer mutation, should they take special precautions, has to pay not the $50 it takes to do the test, but $5,000. And it turns out we have about 25,000 genes. They've almost all been patented at this point. And so far, people haven't quite figured out what these genes mean. But as soon as we all start going to our doctors, and our doctors say, do you want to see if you have the gene that means you'll do better on this medication or that medication? Or do you have want to see if you have the gene associated with this cancer or that cancer or Alzheimer's or autism? The tests may only cost $50, but if we allow every gene to be patented, it would be $5,000 a pop, right? Which is going to be thousands and thousands and thousands of dollars to see are you at risk of certain conditions or not. And the problem is that many, many, many people can't afford that, obviously, and healthcare is expensive as it is. And I would say, so the issue also is not just patenting it, and of course we can get into what should be patented or not, but what does that mean for public health, right? What does it mean if now only very wealthy people can afford $5,000 to find if they have mutations? And by the way, we can also design babies now, so we can ensure that your child does not, we can screen embryos, and people are now doing this, as I describe in the book, wrestling with whether to screen embryos to make sure their children and their children's children do not have a mutation that they have, for Huntington's, for instance. Huntington's is a terrible neurologic and psychiatric condition that Woody Guthrie had, the singer-songwriter. Wrote This Land Is Your Land. If you have this disease, each of your children has a 50% chance of getting it. And if you get it, the mutation, you will die of it if you don't die of something else first. Well, so for many, many conditions, and there may be others like this, to test is going to cost thousands of dollars. And that is of concern. Now, so another issue I would say is not just patenting, but if one does have the patent, one wants to motivate innovation, and research is good. No one's against motivating that. But the question is, how much should one get as a result? Should I be able to charge, if it costs, I spent a few months in my lab, patented something, should I get $5,000 for everyone in the room who wants to now use my, test for my gene? So I think I think these are the issues. And what does it mean in the rest of the world? Is it going to be $5,000 for everyone all over the world who wants to test for the gene that someone discovered in their lab? And I think these are important issues. I would say that, and so people wrestle with this. And I should say part of the problem is that we don't understand genes. So, for instance, with breast cancer, when I interviewed people with breast cancer, they, as I describe in the book, they told me things like the following. The first woman I interviewed said, I always knew I shouldn't have stayed in that awful relationship all those years. I said, why is that? She said, well, that's why I have breast cancer. I said, but you have the mutation. And she said, oh, yeah, but what triggered it is the stress of that terrible relationship, and I always told myself I shouldn't have stayed in that relationship. Or someone else said, I always knew I shouldn't have stayed in that awful job. Why is that? That's why I have breast cancer. But you have the mutation. Oh, yes, but it was the stress of that awful job, and I always told myself I shouldn't have stayed in that. Or women in the South Bronx I interviewed who were African American said, it's all the crap that they dump in the water in the Bronx. They would never dump in Manhattan where the rich people live. That's why I have it. Now, each of these stories may be in fact somewhat true, right? Because it turns out that for many, many diseases, it's a combination of genetics, environment, lifestyle, right? What we eat, etc. But as we go forward, we need research in this. We need research to understand how we should understand these things. It turns out most doctors don't understand genetics. It's new. They're not used to it. It turns out that people are trying to make a lot of money off this. Every drug company wants to get as much DNA as it can because they feel they can patent lots of things. And the problem is a few things. So one, there's also concerns about discrimination, right? So once we have these large biobanks, and I would argue biobanks are a big issue that we're not really dealing with, but once we have everyone's DNA, and we want to understand what causes disease. So we want to see what diseases you have, what diseases your family has, what do you eat, what do you weigh, are you near, where do you live near that might be dangerous. We'll start getting lots of information about people. Well, and if you want to apply for life insurance or disability insurance right now, insurance companies can say, we want to see all the genetic tests you've ever had. They ask that. That's standard. There's no law against life insurance companies, disability insurance companies, long-term care insurance companies saying, to give you insurance, you want to see your whole genetics. And I think the larger point is there's a whole realm of issues that we've not yet faced as a society about what that means. So there is a law for health insurance, the Genetic Information Non-Discrimination Act. So that's health insurance, but not life insurance, disability insurance. There's also discrimination at work. So people say, I told my coworker that I had this mutation, and everyone thought I would be promoted when the boss retired, and instead I was passed over. I wasn't fired, but I was passed over for promotion. And so people are concerned about discrimination in these ways as well. So some of these get into other issues, but the point is that we are increasingly going to have at our access lots of genetic information. It can help us. It can potentially help us in many, many ways. And the question is, how much should we pay for that? How should we use that information? It's like nuclear energy, right? The discovery equals MC2 could lead to lots of cheap nuclear energy, or it could lead to atomic bombs, right? And again, it's similarly with this technology. It's a new technology, and I think we face a lot of decisions about what to do with it. Should we allow people to own the genes in our body, right? I would argue that morally that's problematic. Now, one could say, oh, well, it's the discovery of it. It's not a law of nature. But these, again, are slippery definitions. And I think there's a question, even if the law is X today, I think what the Supreme Court is signaling is we may need to rethink this, right? It's one thing to say, I'm going to patent how to make a phone. But it's nothing to say I'm going to patent something that's in all of our bodies. And I would argue that morally, it's sort of a different set of issues. And I think how we think about our genes as being in all of our bodies. Do we want everyone to know the genes that are in our bodies? That I have a risk of Alzheimer's, for instance? Is that what I want people to know? Do I want to have to pay someone $5,000 to find out if I have that risk? I think these are all complicated issues that we need to understand. And I should say, most people don't know that their genes are in every cell of their body. Most people don't know that we have 46 chromosomes. 40% of America believes that man was created by God 10,000 years ago and does not believe in evolution. And I think the level of scientific literacy and understanding of these things needs to increase. And I think this is also an issue that we need to pay attention to. But the point is that as we face this, there are and as there are many, many personal issues, even I should say, and then I'll stop, is just issues of what it means to have these mutations. Does it mean that we're doomed? Does it mean that we're cursed? Turns out we each have 6 mutations. And again, those may be things that we want to know, but how much should we have to pay for those? Should we pay $6,000 a pop or more? Should there be limits on that? Because even if it is or isn't patentable, this is part of who we are and part of our knowledge, and we have a right to it. I thought I'd stop there, laying a number of issues.
That's great. Well, believe me, this conversation is going to be.
Right.
So, Lee, I believe, correct me if I'm wrong, that you do represent companies generally on these patents, right? So, or
Yes.
have you? You have. So, talk a little bit though about maybe it's a bit of a rebuttal. Do you find that the patents and the ability of companies to get these patents advances medicine? Is it a hindrance to medicine? Are we if a company now has the patent and they're the only ones and they're charging $5,000 for a test, should it be more open? What drives sort of the desire to get the patent?
Okay, well, that's a good question, and I guess I would say I do represent companies and individuals, and I represent them on both sides of these questions, which is kind of the lawyer's lot, So one of the biggest cases I was involved in, we were attempting to invalidate patents for recombinant erythropoietin, which is, anybody know what that is? It's a erythropoietin, which is, the shorthand for it is EPO. EPO is a hormone. It's secreted in your liver. It travels through your bloodstream and it goes to your bone marrow, and it says, we need more red blood cells. Please produce some. The bone marrow produces them. They go into your blood, and you're healthy. If that mechanism is interfered with, you become anemic, and if you're very anemic, you die. So the people who suffer most from this are people who have end-stage kidney disease or renal failure of one kind or another. And even the appearance of dialysis, which was great because it could substitute for the functioning of the kidney, did not solve the anemia problem. So what some very smart scientists figured out back in the 1980s was if we can figure out the gene sequence for erythropoietin, if we can isolate it, and that was difficult because it appears in only trace amounts in your body. It's very hard to get enough to sort of work with it. But eventually it was done, and there was a contest. There was a company in Cambridge called Genetics Institute. There was a company in California called Amgen, and they both had teams of people working on this. And they both came up with the discovery of the sequence. It's 160-some amino acids long. And once they had isolated it in the laboratory as a composition, they were able to apply recombinant techniques to generate a lot of it. And that, in turn, became a medicine that is still administered today, a life-saving medicine for millions of people at this point. And in the race, they were very close in time, but in the patent office and in the courts, it was ultimately decided that Amgen got there first. So Amgen got the patent rights. And those patent rights turned Amgen into the most successful biotechnology in the history of the world. And it still enjoys patent protection today for some of its recombinant EPO patents. They're going to expire in about 2 years, I think. So that's the power of what can happen here. But to try to make it interesting, Robert threw out a lot of ideas, and I'll try to pick on some where I have a disagreement to kind of make it interesting. And let me just go here and say, right here in Massachusetts, we have Tufts Medical School, which does an annual estimate of the cost of developing a new pharmaceutical drug. And that figure is now over $1 billion. $1 billion of investment is required for a company to come up with one of these miraculous new drugs. And in fact, they're in short supply these days. People are talking about something called the patent cliff, which is sometime 4 or 5 years from now in the pharmaceutical industry when a lot of these basic patents, drugs go off patent, and the cliff is there because there aren't enough in the pipeline to replace them. Well, if the money isn't coming in, there's less to invest in the development of new drugs. So that's one example. And a related example is the one that Robert mentioned, this charging $5,000 for these BRCA screening tests. That somehow doesn't seem unfair. But why do the BRCA tests exist at all? It's because Myriad invested hundreds of millions of dollars in the development of commercially available tests. And before that, some researchers at the University of Utah dug, at great time and effort and expense, dug through hundreds of years of genealogical records maintained by the Mormon Church in order to figure out these relationships. So even though we've sequenced the human genome and we know about genes, we don't know what a lot of them do, and we certainly don't know what the relationship is between a particular gene that you might have or set of genes and the medicine or various medicines that might be used to either help you or hurt you or otherwise. And that's the whole arena in which there has to be some incentive for making these things commercially available. And so at this point, let me go into my defense of the patent system. I'll go back to Thomas Jefferson, whose reputation has suffered some in recent years as a slaveholder, et cetera. But he was the person who said we need a patent system. He put it in the Constitution, and he said ingenuity should receive a liberal encouragement. And then Abraham Lincoln, many years later, said that the patent system added the fuel of self-interest to the fire of genius in the discovery and production of new and useful things. I should, in full disclosure, I should add that Abraham Lincoln is the only president of the United States who actually owned a patent, who was an inventor on a patent. In more modern times, some economists have suggested that the whole reason that the Industrial Revolution started in England was because they had a rudimentary patent system back in the 17th century, way before anybody else, so that there was this incentive. You would get your exclusivity for a period of years in exchange for disclosing your invention. And you have to ask yourself, why has the United States predominated in technical and scientific innovation over the past century or two? Why have most medical advances and most pharmaceutical advances happened right here in the United States? Does it have anything to do with the fact that we have the strongest patent system in the world and the one where you do have the ability to enforce your patents? My suggestion is yes. Let me talk about the patent system. It's entirely a creature of statute created by Congress based upon authorization in the Constitution. And the patent bargain is basically disclosure for exclusivity. In order to get a patent, you have to write up your invention in detail. You have to teach a person of skill in the art how to do what you have discovered is a new and wonderful thing. And you have to disclose it. When your patent issues, it's disclosed. In exchange, you get a period of years of exclusivity to the rights to that. And that doesn't mean you put it on a shelf and don't do anything with it. And it doesn't necessarily mean that you hold it all to yourself. People license these things very regularly to deal with the commercial exploitation. But the basic idea is you disclose what you know. And this is an interesting concept because if you can go back in history, you'll find many instances of great minds and great inventors who were afraid to put their ideas out there. They were afraid because they were controversial. They were afraid because they thought someone else might take credit, and for other reasons. So the patent system tries to address that by saying, okay, you're gonna get the credit. You're gonna have exclusive rights for a period of years. But in order to do that, you must disclose your idea. And the patent system has generated a lot of disclosure. A great historical example, I think is worth throwing out here, is Sir Isaac Newton. Some people think he was the greatest physicist of all time. Some people say Albert Einstein was. But if Einstein was number one, then Newton was certainly number two. And he lived in the 17th century and into the 18th century. And he came up with some interesting inventions: gravity, calculus, a few other things like that, fundamental laws of motion. Yet he sat on them for years, concerned about disclosing them and generating controversy, and concerned about other people taking credit for them. So the patent system attempts to address that by saying, you're going to get some exclusivity and you're going to get the credit, but you must disclose the idea. So what the patent system in the United States has come up with as a great insight is that, sometimes there are inventors who they just invent, they can't help themselves. Thomas Edison was like that. We have a guy here in Massachusetts today, Robert Langer, who was at one time the head of the Whitehead Institute, has hundreds of patents to his name. People like this are going to invent no matter what. We have lots of academics who are interested in the truth and discovery and finding things. They don't need a whole lot of incentive. They're going to look. But the great insight that the patent system came up with is, in order to turn these things into commercially viable products that are available for people at large, you have to provide an incentive, because no investor is going to put $1 million or $100 million or $1 billion into the development of a new drug or a new genetic test unless they have some way to assure themselves that they'll be able to get a return on their investment. And that means they need some kind of protection against competitors, because once they show the world how to do it, what's to prevent lots of people from jumping on the bus with them? So that's what the patent system does. And I think this was really captured by a man named Douglas Hart, who's a professor at MIT, who said a couple of years ago that, there's about $50 billion a year that we taxpayers provide to research institutes through the National Institutes of Science and through grants to academics in all different kinds of fields, and through Defense Department grants and Energy Department grants, et cetera. It's great. It's wonderful. I'm all for it. And in fact, I'm for more. But what Professor Hart pointed out was the public is paying for all these wonderful innovations. They're just sitting there in the drawer or on the shelf because there's not $1 in those grants that is put for commercial development. And that's where the patent system comes in. And then finally, in my defense of the patent system, I would just say that the patent system also does protect the public, because first of all, to get the patent issued, you have to show that your invention is new, non-obvious, whatever that means, and we have a lot of fighting about what that means, that there's some kind of inventive step to it, and that it's useful. You must meet those criteria. And if you don't meet those criteria, you aren't going to get a patent. And the patent system also requires that the invention be particularly described so that a person of skill in the art would know how to do it. Now, for these recombinant DNA patents, I certainly wouldn't know how to do them. Perhaps Robert would. But the standard of skill in the art is very high. You have a PhD, you work in a lab, you're doing this all the time, so you know how to do it. So the patent has to tell a person like that how to do the invention. And if those criteria are not met, then the patent's either not going to issue or it's going to be successfully challenged in litigation. So the patent system protects the public in that way by hopefully by making it hard to get a patent and by making patents that shouldn't have been issued susceptible to challenge under the appropriate circumstances. But the basic concept, I think, is the idea of getting from invention, from discovery, to commercial availability.
Thank you. So, do you want to argue against patents?
Sure, yes.
Or-
I have a few.
Okay.
Well, no, I have a few things to say. So, first of all, I would argue the issue is not whether to stifle incentives for innovation. I mean, there needs to be some kind of patent protection for many, many things. The issue is, should there be limits in terms of what could be done with that patent? Not whether, but how to patent, and what the implications should be, and what one can do with that, and should we change the law? And I think those are the key issues. I would say specifically, so in terms of drugs costing $1 billion to develop, the issue there is not the discovery of the molecule. There's hundreds and hundreds of molecules out there that have been on the books for decades. The cost of drug development is to take that drug, figure out for what disease, and to give it to enough people, see if it works, see that it's different from other molecules, et cetera, et cetera. It's not the discovery of the molecule. It's seeing, does it have side effects? How does it compare with current things? Getting it to 3,000 people, seeing it works in animals first. Does it have an effect on cancer? I mean, a lot of drugs may not have an effect on anything. And there are drugs that, lithium was tried for seizures, and it turns out that it didn't help seizures, but everyone felt less depressed as a result. So I would argue that that's not really a good analogy. Second of all, the issue is that the cost of sequencing genes, as I said, has gone in 10 years from $3 billion to a few $100s. So even if it cost millions several years ago, the question is for patents today, where it's no longer hundreds of millions of dollars. You can find a gene for maybe a few $1,000s, right? I mean, for a much, much less amount of money. So it's not the case people investing billions of dollars. The other thing is sort of morally, I would say. We don't believe in owning human beings. We don't believe you can buy and sell human beings. We don't believe in slavery, right? Here we are across from where Lloyd Garrison preached, right? Just right across the street against slavery. And it's a similar issue. Should we own parts of human beings? Is it okay? And I would argue that's a moral issue. You could say, well, the Constitution didn't say anything against slavery, so slavery was okay. Well, we need to change the law. I think there's moral issues there and our sensibilities change. I went to Panama recently, and it turns out that when Balboa walked across Panama and saw the Pacific Ocean for the first time in 1503, he was the first European to ever see the Pacific Ocean. And he said, "I claim this body of water and every land that touches on it to be the property of Spain." That's a quote. Every land that touches on the Pacific Ocean, I claim that we now own it. Now, he spent money to get there. Yes, that's true. But I think there's a question. What's legitimate in terms of ownership here? And I think those are broader issues that we need to discuss. We're also across the street from the Boston Commons. Well, some people have argued that there's a tragedy to the Commons. I mean, so the Boston Commons was set up where everyone could put their sheep, right? We believe in certain things being shared property. Not to say everything, not all of Boston. I can't say I'm going to go into your apartment and that's my property, but we believe in setting aside certain things as shared property. Someone could say, well, you could use, my land, but you got to pay me a little bit for it. Well, the question is what's appropriate. I mean, that's the level of nuanced decision. I think that one needs to encourage innovation. The question is for what? And I think we need to think about, and I should say also, by the way, so it turns out we have about 25,000 genes. They've all been patented. But as I understand it, the level of work that went into patenting and describing the gene has varied immensely. So some people have patented the gene and actually found out what it does. Others have said, well, here's a piece of gene. I'll patent that, right? No one else has patented before. And similarly, think, what if someone had patented, for instance, taking your blood pressure? And anyone who wants to take blood pressure has to pay me $5,000. right? I mean, at a certain point, it doesn't make sense. Like someone invented the blood pressure cuff. We know who it is, right? They, in whatever the year was, they invented the blood pressure cuff and figured out we can check for hypertension. Well, that's a patentable device. And I would argue similarly that people are curious and scientists discover things not just for profit, right? And so for some things, yes, we need companies to do profit, but no one was paying Newton. Newton wasn't thinking, I'm going to try to invent calculus because maybe I can make millions of dollars off of this, right? I mean, people have argued, for instance, that with cell phones, that part of the reason we pay so much for cell phones is that, Nokia has its set of patents, right? And, BlackBerry has its set of patents, and iPhone has its set of patents. And one could argue that's been good. Other people have argued that's actually gotten in the way of innovation. If we had more sharing of certain technologies, our technologies would go up even more. And I think this is the level of discussion. So I'm not against patents. The question is, I think, for some things, we need to have a better definition of what should be patented, how much people should get for it, how long it should last, et cetera, et cetera, et cetera. So, and I think at the moment, too much has been patented, is my sense. In other words, that for people saying, well, I found, the genes responsible for eye color, or whatever it is, or for certain cancers, or just here's a gene, I don't even know what it does, but I'm going to patent that. Anyone who ever does anything with that is going to have to pay me a lot of money. And I think that gets in the way of public health. I should say, for instance, with HIV medications, right, there were recently exceptions made where, given that there are 30 million people in the world with HIV, 29 million outside the U.S., mostly in sub-Saharan Africa, who have, let's say, $5 a day, for $5 a year in health care costs that they can spend. They couldn't afford HIV medications. So at certain points it was decided, U.S.-based institutions decided that we should forego patents on this in the name of public health. And I would argue that at a certain there's a tension there, and at a certain point we need to say that for something that's inside all our bodies, why should someone own something that's inside your body that you may want to know about because it could help you live better? It can help you know how to prevent certain diseases. If you want to find out, is it in my body or not, why should you pay someone else $5,000 for their intellectual property if the test costs $30, right? Imagine if someone whoever invented the microscope with the light to look in the back of your eye that detects all kinds of eye problems, right? If they said, well, I'm going to charge $5,000 for anyone to use that test. I mean, some of this is a little different, obviously. But the point is, if it's in each of our bodies, I think that there's a moral question of what is common to humanity and should not be patented. I can go with other examples. They're all a little bit different. But I mean, let's say the person, Columbus came, when Europeans came to the New World, they discovered for the first time chocolate, vanilla, tomatoes, potatoes. What if they said, I'm going to patent each of these things, and I'm going to charge $5,000. Anyone wants to use chocolate or vanilla or I mean, some of these things are, I think, products of nature. And I think that there is a moral issue about ownership. We don't allow ownership of human beings. We don't allow people to buy and sell kidneys, for instance, in this country. They do in India. You can buy and sell kidneys. You can buy and sell kidneys in the Philippines, in China. But we don't here. And I think that similarly, there are certain things that we think should not be part of the commercial marketplace. And I think, again, these are issues that we need to think about in these contexts. And I would say the people in the book I interviewed really struggle with a lot of these issues. This is part of them. What does it mean to know that I have this mutation that's going to kill me? People say, I live with knowledge of my own death. Some people say, as a result of this, I've changed my life. I know I'm going to have Huntington's disease, so I've decided I'm going to, go be a poet. I'm going to go be a musician. I'm going to move to Tahiti. I'm not going to, or I don't have that. I found out, and so now I'm going to raise a family. These are basic intrinsic things that I would argue are part of being human. And for someone to own that knowledge, for someone to have to pay lots of money for intellectual property, $5,000, 100 times the cost of the test, right? To find that out, I would argue that's too much.
Well, it's been great, and we've already gotten to the point where we want to invite the audience to come up and ask questions. So you would come up to the microphone, just line up over here, and again, if you're speaking into it, you're assenting to being videotaped, as Jennifer mentioned. But
guess the first question I had was, when you start talking about observing the genes, it brought to mind, for many years we've had diagnoses for looking at the blood with a microscope and diagnosing different microbes. I can't think of any of those that were patented, so I'm kind of interested in your opinion on how that compares. So for instance, you know, a doctor looks at the microscope and can observe anemia. And what's the difference between observing anemia or observing a certain genetic sequence? Now, there's a difference where I pay for a test to treat anemia or I pay for the drugs, but that's a different matter. The other question I wanted to throw out, too, was in the IT world, there's been a very detestable practice recently with these patent farm. They're holding patents and they're just selling them. And is that something we see a risk of in the biogenetics world as well, where we have a patent? I forgot the term for them now, but the people that are patent trolls.
Right. Yes. So I agree completely. So the story is basically all 25,000. So the story is there are about 25,000 human genes. Turns out we're 90% the same in terms of genes as house cats, for instance. But half of the genome, we don't know what it is. It's called, scientists say it's junk DNA. Undoubtedly, it's not junk. We just don't know what it does. So many patents now exist, and because no one's found a use for it, I mean, I patented this little piece over here. I don't know what it does, but as soon as so I'm not charging anyone because no one's using it. But as soon as someone starts to find a use for it, you better believe it, I'm going to be charging up the wazoo if I'm a company under the current law. So I think those are problems going forward in terms of people being able to buy and sell the patents is one. Secondly, I agree with you. So, for instance, if we for centuries, there have been many, many discoveries that help our health that nobody patented. So, for instance, figuring out microbes, right? Do I have one bacteria or different bacteria or a virus, right? If I have, take Discovery HIV, for instance. So there was a big race. It turns out that one scientist stole the information from Luc Montagnier in France, right? It wasn't an issue of patenting. It was who's going to get the Nobel Prize, right? And yet just getting the Nobel Prize was enough to motivate scientists all over the world. But one could have said, well, they could have patented it. And they probably, by this logic, one could argue perhaps they could have. And what would that mean then? If we decide we're going to patent to see if you want your flu vaccine, and it has 10 different kinds of influenza viruses ground up in there. If we start saying, if we had said everyone who discovered each of those viruses and each of those variants, whoever found the variant that made last year's flu different from the year before's flu, which is going to influence a flu shot, you see where this is going. People could patent lots of things in science that we somehow have felt they haven't been patented before, we shouldn't start now. I think there was a loophole before anyone really realized what was going on with genes. Things got patented, and the question now is, I think the courts in part are trying to backtrack partly or figure out how much they should backtrack, and I think there's room for backtracking.
Well, let me just say at the start, Robert's characterization of the patent system is completely false. All genes are not patented. You can't get just a patent on a gene. You don't know what it does. As I said before, you have to show that it's new, useful, and non-obvious, and you can't patent something in someone's body. You can only patent a new composition, which is that you isolate in the laboratory to determine what the sequence is. The informational content corresponds, but it's a different chemical composition. And if it's not different, you can't patent it. So that's how the system works. Also, on the incentive front, again, he keeps talking about $5,000 tests, but do you want the tests to exist? If you want the tests to exist, you have to provide an incentive at the commercial level for someone to go through the difficulty and the expense and the thousands of clinical trial patients that will enable you to figure out whether this recombinant DNA sequence will have a positive or a negative effect, whether this chemical compound, and if you go into the laboratories today, you'll find millions of potential chemical compounds on the shelves. The question is, what use is any one of them? That's where the hard work is. And only when you have figured that out can you get a patent on a compound that's going to be worth anything. So that's how the system works. And I would just add to that, again, what I said a little while ago. Most medical discoveries have happened in the United States, where we have the strongest patent system and where you're able to get protection for your patent. Is that just a coincidence? Or is there some correlation there? A lot of economists think there is a correlation, and you need to provide some kind of patent protection in order to get from invention and discovery to the commercial availability of these miraculous new things that we, after a while, we take them for granted, like recombinant EPO to cure anemia, and many other drugs that didn't exist 50 years ago. Where did they come from? Did they just sprang into being? And if so, why in the United States? And let me say one more thing about the rest of the world. I don't know that we can solve all the world's problems in this area, but it's well known in the pharmaceutical industry that you make your profit in the United States market. You make a little bit of your profit in Europe and Japan, and the rest of the world, you don't make any money at all. So the rest of the world, in effect, benefits from these new discoveries and these new things that are developed and created in our innovation-based economy with a strong patent system, and the beneficiaries of these are living all around the world. Now, there certainly are public health issues, and in some instances, drug companies have said, okay, we're going to lower the price for AIDS drugs in South Africa because people there just can't afford them, and there's a crisis there. So we're going to make them available at a lower cost. There's also something in the statutes in the United States that provides the government with a walk-in right in connection with any patent that's issued where federal research money was part of the process. That walk-in right has never been invoked, even though it's there. And so if you have a public health crisis or issue where a patent is a problem, the government has the power and authority to do that. But that right has never been exercised.
I would just say a few things, yes. So first of all, in terms of our having all this innovation, we have the largest economy in the world. For the past, since the war, we are the world's leaders. We spend more money on scientific research through NIH than any other country in Western Europe. So the fact that we have all these innovations, I would argue, is due to the fact that we're the wealthiest country and are spending more money on medical research, not necessarily because of the patent system, is one. Secondly, my understanding is that basically almost all genes have been patented. Now, the companies may not be enforcing the patent because there's no use found for what they've patented, but that almost all genes basically have been patented, and that apparently the standards used have varied. It's different clerks in the patent office. I'm not a patent lawyer, I should say, but this is my understanding from the geneticists I trust, is that for all those patents, functionality has not been established. So in some case it has, it should have been.
Useful, must be useful in order to get a patent issued.
Right.
It must be useful, and that's got to be in your patent application. You've got to be able to read it and see that it's useful. If it's not useful, you will not get a patent.
Well, my understanding is people have written presumed usefulness, that genes are important for disease, and therefore the more we know about if we know genes, that's useful. We may not know the specifics of how it's useful, but of course it's useful to know genes. No one would argue that if I discover a gene, that's not useful. It has to be useful. So it's part of us. It affects how we live, what diseases we get, how we die, etc. But I see other people with questions.
Yeah.
I don't want to hold up. Yes.
Let's move on to some of these.
I want to ask, do genes lose patent protection after a certain amount of time like drugs?
Excellent question. All patents expire after a period of years.
Well, I would think that would be good for bringing the price down. My own circumstance, our family has ovarian and colon cancer, and we are negative for BRCA, which we paid for, a lot of money for, and we are negative for some other gene, I forget the name of it. But we believe that there is a gene mutation out there, they just haven't named it. So I want them working on it.
Right.
Because it can change what our children, what we choose to do for prophylaxis for our children. So that's why if it seems to me to be okay if they lose patent protection, because we know at that point the prices will go down. So BRCA must not have lost patent protection yet?
It hasn't, but it will in a few years.
Okay.
And then it'll be, openly available. Anybody can do it. Anybody can make use of the invention. I mentioned recombinant EPO. That had this very long term of patent protection because there were follow-on patents. But all the follow-on patents are expiring. So in 2014, anybody who has the capability to reproduce those recombinant techniques can produce that drug, and that will change things. We also have in the United States something called the Hatch-Waxman Act, which tried to strike a balance between proprietary drug discoveries and generic makers coming in. And generally speaking, since that act was passed, which was back in the late 1980s, you've had a change in the prescription drug world from a situation where 80 to 90% of prescription drugs were covered by patents, were produced by companies, proprietary companies that had patents on them, to the present situation where generics now make up 50% of the market. And a lot of prominent drugs have gone off patent, like Prozac and Zocor, and the patent for, which I'm forgetting the name of, omeprazole is the chemical substance that's used for heartburn. So a lot of these things have gone off patent. Thank you, Prilosec, yeah. So, so there's now a lot of price competition and a lot of lowering of prices.
Thank you.
I could see patenting a method for discovering whether the BRCA gene has the mutation or not, but I don't see what the point is in patenting that gene. And if the method was patented, someone could presumably try to find a competing patent and do something. So what is being patented when you patent a gene?
Well, what's being patented is not a gene, but an isolated gene sequence, which is something that you've extracted it from the body, let's say in a blood sample.
This is the the one that hasn't been mutated?
Well,
the gene that hasn't been mutated?
It may or it may not. You don't know when you get your sample, but you examine the genetic material that you come up with, and you figure out what the sequence is and what the composition of the gene is. And when you get it in your laboratory, there's various forms of it, but any one of them are different from the form that it takes in your body. You have, Robert mentioned these 4 letters that come in a particular sequence, and they define characteristics. Well, those letters will appear in the same sequence in the laboratory material, but there will be other dimensions of it which will be different. It will be missing something called introns. It will have different chemical characteristics at the atomic structure.
You haven't answered my question. You're patenting a certain sequence. How can you charge $5,000 to test whether someone has that sequence or a variation of it? And why can't someone else decide on a different way of testing for that sequence? What exactly does the patent cover?
So this is an important issue, and I would say it includes the same sequence. What's patented and what's in your body is the same sequence. It's like saying, if I have a book and I take
no,
out
no,
the
but different people have different versions of this patent. Some people have mutations. So what will,
So you-
were all the mutations patented?
Yes, you can. So basically, if I have, let's say, ACTG is a gene that makes our, makes our eyeballs or makes our corneas.
Yeah, you have a sequence, say, of 1,000.
1,000 things, right? Okay.
Yeah.
Now let's say there is an error in that.
Yeah.
So I should say what defines gene. There's actually debate what is a gene, which is another story. But it's thought that a gene is the group that then forms a protein that does something. So it can form a protein, and that protein is like a building block. Could then make part of your hair, part of your skin, part of your liver, whatever it is. What he's arguing is that in the sequence of these genes, let's say it's 1,000 letters in a row that make the protein. There is a little sequence in the beginning and the end that say basically start now and end here, right? And the only difference, the reason you're saying that it's not what's in your body is because they're taking out the beginning and the end, the start here and the end there. They're taking what's in the middle. But I would argue that it's completely what's in all our bodies.
No, it isn't. Because some people have mutations.
Okay, right. Except for the people with mutations. In other words,
Which is important for cancer.
right. So the story with mutations is that, just as background, when we take these 3 billion letters in each of us, and by the way, 3 billion letters, if you imagine this is a wall of books, that's about 3 billion letters. And we differ, we're 99.9% of the same, which is if you pull one book out, that's the amount of the wall of books, that's the amount by which we differ. Now, when each of our bodies makes those 3 billion letters, there's around 3,000 typos that are unique to each of us, right? Now, those typos could be nothing. They could be, if I spell my name Robert, R-O-B-R-T, you still know it's Robert. But if a typo changes you from Mr. to Ms., right, that's a big difference, right, if it's just one typo. So some typos become mutations in the sense that, or they become pathological mutations. So anyway, getting back, my understanding actually is that it's the gene itself, because it turns out that for any gene, there could be many mutations that will make the gene not work and therefore can cause disease. And I think what the BRCA, well, I'm not sure if you know. I think I imagine it's the mutated version is what they patented, but I'm not sure.
So we.
But
I apologize, but we
when
have
they
some
examine
people
you,
behind you.
They're examining whether
Sorry.
you have the mutated version or not. But suppose someone else decides on another way of making that decision. Can
Then I
that
would-
be patented?
Under current law, I'm not sure. I don't know if you know it's a patent law.
I'm not sure
lawyer.
I understand the question, but the mutated version is the patented one.
Yes,
There's
okay.
two of them, BRCA1, BRCA2.
Right.
And the patent covers the structure itself, not in your body, but the structure in the laboratory. So if
Which is
you
the same.
you have to use a laboratory technique to measure the patented item against what's in your body.
Well, what if
Sir,
I use...
sir, excuse me. I'm sorry. We've spent 10 minutes
Yeah,
on
but
this
you
question.
haven't answered the question.
I apologize. I think they've both tried very admirably to
Well,
answer the
these-
question.
It
and-
shows that it was a good question.
And we want to continue the conversation
Stumped
with the
us,
people
Bob.
behind you. Thank you.
Hi, I have something a little different. On the area of keeping your genetic information safe, why wouldn't HIPAA rules cover that? I mean, it covers it once you have the disease, so why wouldn't it cover your propensity to have the disease?
Because if I'm a life insurance company and you come to me and say you want life insurance, you sign over to me your right to have access to your information because you want life insurance. In other words, I'm a life insurance company. I can't just automatically get everyone's genes. But if you say to me, you want me to give you life insurance, I then say to you, fine, that's fine. Just sign here that you'll give away your genetic information. And if you don't want to sign it, I'm not giving you life insurance.
I don't know, that sounds a little simplified, because I don't have to give my information to other businesses, so, including my health care. I don't have to give health insurance my genetic information.
That's because there's a law. There are laws protecting in terms of in terms of protecting your the GINA, the Genetic Information Non-Discrimination Act, specifically says that group health insurance plans cannot discriminate you based on your genetics. There's no such law covering people who want to get life insurance or disability insurance or long-term care insurance.
Okay.
Thank you.
I'm a little simple-minded in thinking about some of these complicated issues, especially the economics. Like, I have 2 points. One, where does $1 billion come from that these companies use? And 2, if they take the genes and they study them in a petri dish or whatever they do they pay the person from whom they took the genes?
So I'll answer the second one. Some of you may know there was a book that's still on the bestseller list, The Immortal Life of Henrietta Lacks, that looks at this issue, which is, for those who don't know, there was a poor African-American woman in Baltimore in the 1940s or 50s. She had cervical cancer. The scientists had some of her cells, and they were able to grow them in petri dishes, which was the first time human cells grew in petri dishes. She didn't get any money, and her family's still poor and has no health insurance. Now there is a consensus, usually, which is that to be in research, you sign that you'll give us your DNA, we'll give you $100 for coming in, but if we discover something, we're not going to give you any
That's a
part of the
protection,
profit.
yeah.
Now, people argue that. It's an extremely arguable issue. The bottom line now is that there's informed consent so that you know in advance that we're not going to give you part of the money.
And how about the $1 billion?
The $1 billion is what the pharmaceutical company puts into its research activity in order to come up with
And
the next generation
comes out of their
of drug.
profits, or do people
Yes.
or do other people put money in? Does the government put any money into that?
No, it comes out of the company makes money, and it allocates a significant portion of it to further research in order to come up with.
Because I can't believe the government doesn't put any money into the development of the drug.
Over time, if I could say, there have been cases where the government has. So there was an Orphan Drug Act, for instance, about 20 years ago or
still
so.
in effect.
Right, which
Still in
is, in other words, for obscure diseases, right? Drug companies said there's not a big market for disease X. It only affects 1 out of 100 people. So we will give money to companies, I'm filming the details, basically to incentivize companies to develop drugs for those specific things. So sometimes there is public money.
Thank you.
Thank you.
It's clear that there's a public policy for exclusivity, and so I have a 2-part question for both of you.
Okay.
First of all, how long should that exclusivity be? You know, what's reasonable? And secondly, has there been any thought to having different periods for different categories of patents? So, you know, both of you, I'd like to have your opinions.
Okay, well, the way the statute reads now, your patent will last the longer of 20 years from the date you apply, or 17 years from issuance. So if, I'm sorry, the shorter of. So if you're, and a patent going through the patent office, an application going through the patent office, particularly in this arena, typically takes many years. So the life of these patents on gene sequences or on pharmaceutical compositions or on antibodies, things like that, is typically going to be 12, 14 years. There's a very complicated set of statutory requirements for getting extensions where there's delay caused to your application by the fault of the patent office as opposed to your own fault. And so there are actually conferences at which lawyers debate about these issues. So it's a complicated set of questions. But the longest it can be is 20 years from your application. And that's the existing system. And typically, it used to be 17 years from issuance, but that was changed in the 90s as part of harmonization of U.S. law with the law of other jurisdictions. There are some areas where patents have shorter lives. Design patents last only 14 years, but they're very different from utility patents. And then there are plant patents that also have a different lifespan, shorter lifespan.
I agree. I think we need to rethink patent law. Should there be limits in certain ways, be it length of time or how much could be charged as a result? And I think this is an ongoing area that we all need to think about. I should just say, by the way, partly in response to the early woman's question, I mean, these are central bioethical issues, and this is, some of you may be interested in following up on this. If you search bioethics, there's a lot of material that looks into a lot of aspects of these, and some partly questions we didn't have a chance to answer fully, et cetera. And I know Columbia, we also have a bioethics program where we train people to look at these issues. I'm sure there are places here that do that as well. But I think that these answers we can't easily resolve here tonight. But I think to go forth and think about them more would be a great thing.
Okay, so my question has to do with the whole incentive concept behind the patent system, which I can appreciate because I'm an engineer and been involved in a couple of patents myself. So take the $5,000, the $5,000 test. It costs $3 billion or whatever to develop, and the money that comes in subsidizes, pays back those investors with what you could consider some kind of a fair, return profit to make it worth their while. Okay, so to what extent is the $5,000 going to that purpose, and to what extent is it becoming this killer app game where I'm going to create something that is going to make me super rich, and I'm king of the world now because I've solved everything. And the question is there a point at which you say, okay, you win, now it's time to think about the greater good, and how close do we come to that point or go beyond it?
Well, that's a tough question. I'm not sure I know the answer to that. I think there are many patents that turn out to have zero value, despite the earnest desires of the inventors or the companies that put a lot of money into them or what have you. And then there are others that, for reasons that are sometimes hard to understand, turn out to be very valuable and produce windfalls for people. And then there's obviously a lot in between. So,
I think that's a critical question.
Thank you both. It's a really wonderful debate, and I think two very compelling points of view. It's like watching a terrific tennis match where you serve, return, and one winner after another. And it, which really prompts my question. There's a lot at stake here, and as I think Bob points out, it's just sort of the tip of the iceberg as we head further scientifically. Are there, at a federal level or perhaps outside the government, fora where people from industry and academic and other institutions and points of view trying to come together to ask the question of whether the law as it exists ought to be modified, and to what sort of progress is being made in that direction?
Well, I think it's in the courts now. I think the Supreme Court, I mean, you should fill us more in this, but basically has said it is not going to rule officially on this, but sort of gave a sense of what it wanted the lower court to then do. And I think my read of that is that it wasn't quite clear how what the Supreme Court said was really going to guide the lower court. And of course, then Congress can step in depending on what the court says. But again, I think that I don't think we as a people understand these issues well enough. I think that, as I said, this is all so new. When you think about it, that 10 years ago, nobody's genome was sequenced. Nobody's 3 billion letters. And now, the level of the amount of biotech and science has gone like this, as you know. So, literally, as you know, I mean, every week there are new mutations being found, and there's a lot of misunderstanding, I should say. I mean, just look at media headlines talking about, the alcoholism gene, the fat gene, the intelligence gene, the smart gene. Even when at the 50th anniversary of the discovery of DNA, Jim Watson of Watson and Crick, who discovered it, said, he asked, what should we do now? He said, we should discover the stupidity gene so we could get rid of it. Well, there undoubtedly is no stupidity gene, but I think it suggests how we want simple answers here. And, we can't even predict the weather, right? They say 30% chance of rain. It may rain, it may not. How often is the weather report wrong, right? And all that matters there is taking an umbrella or not. Whereas here, I would say, the level of what this means in terms of predicting, are we going to get disease? Are we not going to get disease? Will we get a certain drug? What all this means? It's of an order of magnitude so much higher that I think we're just at the tip of the iceberg. I think it's like this is 1492 and Columbus says he just discovered something very important. He discovered a few islands off the coast of India. Well, he didn't discover a few islands off the coast of India. He discovered there were whole continents there that he had no idea about. And so, as you say, this is the tip of the iceberg, and I think we can't just leave it in the courts. I think that we need to inform Congress, each other, have open public debates about it, et cetera.
I guess that's my question. I'm sorry.
I was going to say, in response to your question, there's a lot of debate on these issues among various groups, industry groups, lawyers, legislators, et cetera. And in fact, we did have, Robert's comment about it's now in the courts, it's been in the courts for hundreds of years. And actually, let me trot out this one example, and we'll take a poll of the audience. In 1855, the Supreme Court addressed the question of whether a particular invention was obvious or not. And the invention was taking an eraser, which already existed, and taking a graphite pencil, which already existed, and putting the eraser on the end of the pencil. Now, it hadn't,
And there's the inventor.
it hadn't been done before. So how many people think that was obvious? How many people think it was a new idea? Well, the Supreme Court in that case said, obvious.
And
they
erased it.
Right. I agree with the audience. I thought it was a new idea. But anyway, so they're in the courts, and I see Judge Cass here with a question I'm very interested in. But before we do that, I just also wanted to say to the gentleman who stepped up before, we did have new patent legislation called patent reform legislation in September of last year called the America Invents Act, which did a lot of tweaking and changing of rules in various ways.
So it is about 5 of 8, and our program ends at 8. So
just
we
to
do have our great last question from our board member.
Just to demonstrate, Dr. Klitzman, that there may indeed be a stupidity gene, I ask Mr. Bromberg, what patent did Lincoln obtain?
It was a patent for making it easier to have a flat-bottom boat go over rapids in a shallow river. Because you remember, he did have a life as a river boatman before he got into politics.
Perfect note on which to conclude. Thank you.
Thank you, Rudy. So this has been a great conversation. Thank you, guys. I will just ask lastly, because this has been a very good back and forth, and quite honestly, of all the forums I've moderated, the easiest one for me, because I think I said hello and let it go, right? So, so thank you both. Do you have any last comments? Do you have anything you want people to take away from this conversation? 30 seconds to a minute. Let us go.
I think these are issues, and what genetics means to us are issues we all need to deal with in a larger sense as well. And I think that to understand that, as I tried to present in the book and as other people have talked about as well this evening, I think is a central issue that we'll all have to deal with in our lives in upcoming years.
I would agree with Robert. I've made it clear that I'm a supporter of the patent system, and I think it works well. It obviously needs tweaking from time to time, but I think that the issues the ethical issues, the moral issues that come from these amazing discoveries that we now live with will be with us for a long time to come.
Thank you.
Big hand for our speakers. And I'd just like to end the night on a complaint. I left the room for 10 minutes. My mom's up at the mic when I come back, airing my genetic laundry. And you weren't listening to Bob, because now Dominic's going to pass me over for that big promotion to super executive
Is
director.
there anywhere to go?
Bob is driving to New York tonight and then getting on a plane and going to Vancouver. And I want to thank you for just coming out here for this. If you would like to thank him, go buy his book. It's right out there, and he will sign it for you before his car comes to pick him up. Thanks a lot. Have a great night.
Thank you.